The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Can't hear you, Judge Dillon. You're muted.
Can y'all hear me now? I'm sorry. Yeah, I'm Judge Chris Dillon. Welcome to the North Carolina Court of Appeals. I apologize about that. We have one case, and I will just introduce Judge Inman and Judge Young, our other judges today. And we have the case this morning is the State of North Carolina versus Campbell, and we do have a clock there that we'll follow fairly closely. But if questions are being asked, don't let it bother you. I'll let you know when your time's about up. And we will hear from the appellant first. And so if you're ready, you can proceed.
May it please the court. My name is Amanda Zimmer. I'm an assistant appellate defender, and I represent Eric Campbell. I'd like to reserve 5 minutes for rebuttal.
Okay, that's fine. Thank you.
Sins of the father are visited upon their children isn't just some dramatic or theatrical saying. This case is an example of it. 21-year-old Eric faced trial alone for crimes instigated by his father, a father who killed himself rather than face a capital trial. Eric's trial was fundamentally unfair due to the exclusion of Ed's statements and because of the lengths gone to keep a juror deliberating after she indicated she was unable to evaluate the case and after she was in a car accident. As a result of this trial, Eric will spend the rest of his life in prison. I plan to discuss issue 3 from the brief related to the issues with Juror Whitney first, and then discuss issues 1 and 2 related to Ed's statement. Turning first to the issues with Juror Whitney. This case is unique. It involves a month-long break in jury deliberations during the guilt phase of a capital trial. And issues arose quickly during the deliberations. The case was submitted to the jury on Thursday afternoon, and by Friday morning, juror number 3, Juror Whitney, had sent out a note indicating that she was feeling unable to properly evaluate the case. At that point, the judge did not make any inquiry of her and instead gave the jury a long weekend, recessing court at about noon on Friday. On Saturday, Juror Whitney was in a car accident. On Monday, the court brought all the other jurors back and the attorneys and learned about the accident and was informed she would have to have surgery. 2 days later, Juror Whitney returned before the court and informed the judge that she would need to have surgery because her arm was broken in 4 places and that it would take about 2 weeks of narcotic painkillers before she would be released from her doctor's care. At that point, the judge recessed the case until Monday, August 28th, in order for Miss Whitney to have her surgery and to begin her recovery. On Monday, August 28th, the full jury reconvened for the first time in a month. A limited inquiry was conducted of the jury before they resumed deliberations. Less than 2 hours later, they returned guilty verdicts to all 7 felony counts. Eric undoubtedly had a right to an impartial jury of 12 jurors. This court has recognized that the requirement of neutrality and the appearance of impartiality are vital safeguards, fiercely protected by our courts. And to this end, the trial court has a duty and responsibility to make an investigation to ensure that jurors remain impartial, uninfluenced by outside forces, and free from misconduct during deliberations. And as this court recognized in Salentine and Drake, what constitutes juror misconduct is determined by the facts and circumstances in each case.
Let me ask you a question. Tell us what the standard review is here. Is it an abuse of discretion all through, as the state purports?
It is an abuse of discretion, both for the issue of whether Juror Whitney should have been removed and for the issue of whether or not a mistrial should have been declared.
So it's not a harmless beyond a reasonable doubt kind of analysis.
When it comes to whether or not Mr. Campbell's right to an impartial jury of 12 was violated, I would contend it is either a harmless beyond a reasonable doubt standard or structural error as recognized in State versus Wilson, where if there are less than 12 jurors deliberating, that is a structural error and automatically reversible.
But were there, if you could just connect those dots.
Yes. When juror
That wasn't the case here, was it? Right? There were 12 jurors deliberating. It's just the timing that we're here about, right?
Well, no, it's not just the timing, Your
Okay.
Honor. I think it's more than that, because the first note that comes out from Juror Whitney is a statement from her that she's feeling unable to evaluate the case. So we don't know if she was participating in the deliberations at all that Friday morning. We don't know what she was doing. What we do know is that when she came into the courtroom, she was visibly upset and distraught. And at that point, the judge did not ask if she had been participating or ask what she meant by how she was feeling unable to participate. So at that point, we really don't know if there were 12 jurors. And then when we do come back, when she comes back on that Wednesday after she'd been in the car accident, she says she was feeling very overwhelmed by the instructions and that she didn't.
Excuse me, if I could ask a question. If you go back to when the jury came into the courtroom, you described the juror as being visibly distraught. What questions were asked at that point by the court with regard to her ability to continue to participate in the deliberation?
Your Honor, at that point, no questions were asked of the juror. The trial court just decided to give the jury an early recess and allow them a break. And it's during that long weekend recess that Juror Whitney is then in a car accident. So at the point when the note is received by the court, there is no inquiry of this juror at that point.
Okay, thank you. I'm sorry for interrupting.
And then when Juror Whitney does return on Wednesday, she's asked very little about what was going on Friday. And she's asked a lot about what is happening with this car accident, which is understandable. She was also very concerned about how the car accident looked to the court. She was concerned that she would be charged with something as a result of this accident and inconveniencing or delaying this trial. So the combination of her being unable to evaluate the case on Friday and then coming back on Wednesday and immediately being concerned that she was going to be in trouble, not only for not being able to evaluate the case, it seems, but also because she was injured in a car accident and required medical care. So this starts to create an appearance of partiality, an appearance of coercion to get this juror to continue in this case. We start to question what's going on here. And as this court recognized in Drake, when we're talking about juror misconduct, we need to think about prejudice, not just in terms of prejudice to this defendant, which there was, but prejudice to the system. How does this start to look? We have a juror on Friday say she cannot evaluate the case. And on Wednesday, she comes back and tells the court she has to undergo surgery to fix a bone that is broken in 4 places. She has to be under a doctor's care for weeks. And the judge says, come back 4 days after you are released from your doctor's care so we can continue this case. At that point, the juror should have been removed from the jury. So that's the first aspect of this juror issue. Was it an abuse of discretion not to remove this juror, either at that point or on August 28th when the whole jury returned and there had been the question of additional contact? And everybody involved in this proceeding understood that if the juror was removed, it would cause a mistrial. And that is because the judge knew he could not replace a juror once juror deliberations had begun. So the issue of a mistrial sort of is twofold here. It comes in as a result of removing the juror, but it's also a separate request made by the defendant in his motion to remove juror number 3. So the result of removing the juror would have been a mistrial. And then additionally, just because of the length of time and this break and the conduct of Juror Whitney during that break, there should have been a mistrial. So there's sort of a twofold issue there related to the mistrial. And here, it was clear that everybody, including the judge, was concerned about having to declare a mistrial in this case, which did take a long time. But that is not a reason not to remove a juror under these circumstances. There are many examples from both this court and the North Carolina Supreme Court where jurors are removed for less egregious issues, for less severe injuries. They're removed because they have a cold. And here we have a juror who had to undergo surgery and recovery, who did not have, from what it appears, the full use of her arm back at the time she was deliberating, and who in fact wasn't even cleared to return to work at that point. But we put her back in a jury room to decide Eric Campbell's fate. And this was literally a life or death decision. This was a capital trial. Even though Eric ended up with life, at this point, he could have faced a death sentence. And this is the juror that we kept asking to come back and deliberate, even though it was clear she was emotionally distraught, she was physically in pain, and we keep bringing her back. So in this case, we contend that this was an abuse of discretion not to remove that juror. It was not a reasoned decision. It was an arbitrary one based solely on the resources that had gone into this trial and the desire to avoid a mistrial.
Okay.
And the court turned somewhat of a blind eye to what was going on. He did not ask what the juror meant when she said she couldn't evaluate the case. He did not clarify why the instructions were overwhelming. He did not repeat the instructions when the full jury was brought back. He did not directly inquire about whether this juror had tried to contact defense counsel over Facebook. And when he made his inquiry to ensure she could be a fair member of this jury, he asked her leading questions that ended completely with, "Is this correct?" And each time she said, "Yes, sir." And again, we have a juror who has expressed concern that she is in trouble, that she is going to be charged because she was in a car accident and because during deliberation she became unable to evaluate the case. And the appearance of this is simply one of unfairness.
Can you remind us, and Ms. Zimmer, I apologize that I don't have it tagged. I'm trying to look in the transcript where this is happening because I'm trying to remember whether Mr. Tyndall attempted to ask any questions of this juror.
This begins in volume 39 of the transcript, starting at transcript page 6,629 and continuing from there. Mr. Tyndall multiple times asked for further inquiry. At one point, the state clarifies that they do not want to reopen voir dire, and the judge says, "Yes, I recognize that, and that's why you're not asking questions." So each time Mr. Tyndall said, "I may ask for more inquiry after that," and he did ask for additional inquiry multiple times of the juror, but at no time did he really directly ask to question the juror. And I think that is out of deference to the trial court's procedure that he planned to follow, and saying he would ask the questions, or implying he would ask the questions.
But
So if you look, I'm sorry,
but then did he ask the questions?
the trial court, no.
No, Mr. Tyndall.
No, he was not given the opportunity to directly question the juror.
And he asked for that, and he was told he couldn't.
I'm not sure that he ever directly asked to question the juror. He repeatedly asked for the court to conduct further inquiry and pointed out things that he felt were deficient, but I don't believe he directly said, "Your Honor, may I question this juror?" And again, I think that was partly in response to the acknowledgement that they were not reopening voir dire to allow counsel to inquire of the juror.
Okay. Thank you.
So again, this is an abuse of discretion standard, but as the North Carolina Supreme Court recognized, the discretion of the judge ought to be used to the end that both the defendant and the state receive a fair trial. And here, what we have is just an appearance of forcing a juror to continue under circumstances where, if this was a drug case, a mistrial would have been declared and we would have started over. But this case, the most serious kind of case that we have under our law, for first-degree murder where death is at issue, we did not remove this juror and declare a mistrial. Instead, even though she had to have surgery and even though she was in pain, we forced her to continue to deliberate. And that simply creates prejudice to both Mr. Campbell and to the system.
Can I ask you, Ms. Zimmer, just hypothetical? I think that, the jury had started deliberating the day before, had a couple of questions, and now we're on day 2.
Mm-hmm.
My understanding from the transcript is the alternate jurors were still there. They hadn't been released by the trial court.
That's correct.
Just to make clear, the trial court could not have excused juror number 3 and substituted with an alternate at that time.
No, Your Honor. At that time, the juror could not be replaced due to the North Carolina rule that once you have 12 jurors deliberating, those same 12 jurors must complete the whole case. So at that point, there was no option to replace the juror. If Juror Whitney had to be removed, this is where I've said it would have caused a mistrial because the judge could not have replaced her with an alternate, which obviously is different than it had this happen during the trial proceedings. And when you're talking about the system, I think it's also important to point out how this impacted the other jurors. In this case, the jury had been summoned, released, brought back for trial, heard approximately 12 days of evidence, looked at over 700 exhibits, and finally was told they could think about the case and start to reach some decisions about guilt. And then they're told to go home for a month and not think about this case. They were completely at the whim of Juror Whitney and held in limbo. They were inconvenienced by this trial, and that's an important part of our civic duty. But this decision to keep Juror Whitney and keep deliberations going forced them to draw out an already difficult and time-consuming process. And when they came back on August 28th, they all said they had not thought about the case. They'd not had any contact with anybody involved in the case. And I think that that's unbelievable, to be honest. I mean, this is a hard case. This is a difficult case. It was a capital case for a reason. And to think that these jurors went home and just went about their daily lives without having this hanging over their heads just seems unrealistic to me. And in that time, they also probably forgot details. This had been days of presentation of evidence. This involved DNA experts, medical examiners. This was not a simple case. And under these circumstances, it is clear that this procedure created prejudice for both Eric and the judicial system, and that a mistrial should have been declared. So on this basis, we would ask that this court find a violation of Eric's right to an impartial jury and remand for a new trial. Unless there's any more questions about the juror, I'll briefly discuss Ed's statements.
I've got one quick question, Ms. Zimmer, if you don't mind. So when the jury was released to go home and resume the normal activities of their lives. They were not sequestered. Is that correct?
That is correct.
Okay. All right. Thank you.
They were told to go about their daily lives and that the court would call them back. So again, they're being held in limbo at the whim of the court and this juror to see how this juror's surgery goes.
Okay. All right. Thank you.
So turning now to Ed's statements. Our North Carolina Supreme Court has recognized that it is an established principle that in criminal cases, every circumstance which is reasonably calculated to throw light upon the alleged crime is admissible. And here, Ed's statements were relevant and certainly threw light on the alleged crime. And here what we did, we started with pieces of Ed's statement to determine if those were admissible, instead of starting with the whole and then cutting out parts that were not admissible. And here the jury heard only bits and pieces of what Ed had to say. And again, here this case is unique. We have two recorded statements from a co-defendant who died prior to trial, who was unavailable. And Eric gave multiple reasons to admit these statements, whether it be hearsay exceptions, the constitutional right to present a defense, and whether they corroborated Eric's in-court testimony. The trial court found that several of Ed's statements were against his penal interest, and there's a list of those on pages 20 to 22 of the brief, and I'm not going to repeat them all here. And within these incriminating statements, there are also statements about Eric's actions at the time. And the state has argued that only to the extent that any statement against penal interest is admissible, it's only the small, narrow statements. But in State versus Wilson, the North Carolina Supreme Court said, you have to give the context of these statements. So to the extent that the state contends only a very narrow portion of this was against penal interest, I think you have to look at the broader statement to understand those statements. And here, the statements were corroborated and sufficiently trustworthy for the reasons in the brief. And I think it's really significant to just point out again that the trial court did admit portions of these statements. So the court did find sufficient corroboration and trustworthiness for parts of these statements, but overall did not find that all the statements could come in. And certainly these were lengthy statements and it would have been a lot for the jury to wade through. But by asking to admit the whole statement, it gave the jury the opportunity to take them in context, which was both helpful to Eric and at times harmful to Eric, because as the state argued at trial, they had portions of Ed's statements that were very damaging, that were very unflattering, and as the state argued, it allowed the state to point out the weaknesses of Ed's statements. So to parse these statements down too narrowly and only admit portions of them really gave the jury less than the full picture here. And after the first time these statements, the first time the defense moved to admit these statements was very early in the trial, and the trial court said, not yet. We're not there yet. And then the second time they tried to admit them, they said, you can admit some of these. Some of these were there.
I'm saying that the trial court erred in not admitting these statements. So what's the standard review on this one? Is this prejudicial? Is it harmless beyond a reasonable doubt because of the Sixth Amendment? I mean, what is the standard review here? How does that work? Let me get that in my mind first.
I think if the trial court erred by not admitting these as an exception to the hearsay rule, then I think we're talking about reasonable possibility of a different outcome had these statements not been admitted, had these statements been admitted. And then if we are talking about the Sixth Amendment right to present a defense, then we are talking about the state showing this is harmless beyond a reasonable doubt. And I think under any standard, this was prejudicial because what happened in this house was tragic, but we don't really know who did what. There was not a ton of forensic evidence. There were no eyewitnesses. What happened to the Faulkners was not clear.
What was the state's theory? Did the state argue that your client actually pulled the trigger and did stuff, or did they just was their basic thing was he was there and he must have been involved because he helped dispose of the bodies and whatnot? I mean,
the state. Sorry, Your
no,
Honor,
go ahead. I'm sorry. Go ahead.
The state's version was that given the amount of the injuries, this could not have been a one-man job.
Okay.
So they contended that Eric actively participated, though I do not believe they ever represented particular acts of conduct that they were accusing him of doing, except for to say they both had weapons available and this was not a one-man job.
And you have about 2 minutes. You have 2 minutes before you eat into your 5 minutes. I just want you to be aware of that. You have about 2 minutes now.
And as for
Sorry. So at the state, of course, there was an acting in concert instruction.
Yes, there
and
was.
the jury had a question about that
yes,
instruction. And under acting in concert, it wouldn't be necessary for your client to have struck a single blow, right?
no, it would not have been necessary. All that would have been necessary was that there was an agreement and a shared purpose. And of course, at trial, Eric adamantly denied that there was a shared purpose or that there was a plan to commit these crimes. So his defense was that there was no agreement. He was there, but he was not part of a plan to commit these crimes.
Well, I mean, there is case law, of course, that says the juror can infer such agreement from activity after the fact, like driving away with the bodies and not going to the police, but continuing to flee.
Yes, Your Honor, there is.
Did the jury hear any statement made by Eric's father that Eric's father said that my son had nothing to do with it? Were any of the statements that came in to that effect said nothing? They never heard that Eric's father had said that he had nothing to do with it.
No, they only heard that from Eric on the stand when he denied that he had anything to do with hurting these people and their dogs.
Okay.
So just to briefly summarize, so I have my time for rebuttal. There's no question in this case that Ed's sins were visited upon Eric. He was left to defend himself without the jury being able to hear most of what Ed said and nothing about what he said about what happened in the Faulkner's home. Eric was the only one left to hold accountable for these crimes, and the trial court forced a juror who was unable to evaluate the case and who had been in a car accident to continue to deliberate. The prejudice to Eric and the system from these rulings is clear. For the reasons argued here and in the brief, Mr. Campbell respectfully requests that this court grant him a new trial on all charges. Thank you.
Thank you so much. We'll hear now from the appellee from the state.
May it please the court. I'm Teresa Postel with the Department of Justice, and I represent the state. The three issues defendant has raised are all without merit. The trial court did not commit reversible error by excluding the defendant's father's own unsworn pretrial statements, and the trial court did not abuse its discretion in denying the request to remove a juror and declare a mistrial. I will just begin with issue number 3, since the defendant has focused primarily on that. And I want to point out first that the trial court did not just decide that the juror should return. The defense did not ask repeatedly and multiple times to ask questions. This is on, it begins on page 6629, and that's when the note comes from the jury. The note indicates that the juror is feels like she's unable to continue and wants to be excused. The defense attorney's response when the judge read the note was, I understand that would cause a mistrial, and I'm uncomfortable both ways. I really don't know what to say right now. That's on pages 6629 through 30. So the court suggests a jury instruction, and the attorney responds, I'm trying to rethink about that. So at that point, the trial court suggests, and I do want to point out, please look at this. Every time the trial court made a suggestion, it was just that, a suggestion, and it asked for input from both parties before and after it did anything with the jury. So the court first suggests a 10-minute break to give everybody time to consider this just after the defense attorney says he doesn't know what to think or what to say. And the defendant's attorney's response is, that is acceptable to the defendant. The court then, after 10 minutes, says that he would suggest a break for the weekend, and that's because they had been discussing some sort of suggested instructions. And the defendant's attorney responded, well, if the court does that, that is having them come back over the weekend with an instruction that would hopefully refresh everyone, the defendant would be satisfied. That's on page 6636. When they return on Monday morning, that's when they do get the note that the juror's been in a wreck, and has a doctor's appointment that day. So they should find something out that afternoon. And the court then suggests that he send the jury home, and that they would bring them back when they find out when the juror would be available. They should know that afternoon. Ask the defendant if he has anything to say about that. He has nothing to say. And then when the court suggests jury instructions, the attorney says, we'll just digest and think about that. So they come back on Wednesday morning because the court has invited the juror for inquiry. And before they bring her out, the court asks defendant's attorneys anything on behalf of defendant. And he says, well, I just want to make sure that you are going to ask questions. anything on behalf of the defendant. At that point, the answer was blatant no. That's on page 6646. So the trial court is now asking the juror questions. And of course, she's just been in this car accident. She has a surgery scheduled, but she hasn't had surgery yet. So the court asked several questions. She actually indicates that she did not want to do this because it's much harder than she thought it would be, but that she would do it if she had to do it, that she had made the request, but she would continue. So the judge asked the parties if they want to be heard further, and the defense attorney explicitly states, the defendant is not asking for any more questions at this time. We are not sure she can evaluate this right now. That's on page 6650. The defense attorney then says, I assume you would intend for her to return when she's medically released. And then the defense attorney says too, because the court suggests some more jury instructions, and the defense attorney says, I don't think that's necessary at this point. I don't think Alan is necessary either. But we may know more when she returns on the 28th, because that's going to be a long break. We may know more, and we would we would need to inquire with everyone at that point. That's on pages 6655. So the court says, okay, we'll revisit that when we come back, and also go ahead and think about what further inquiry you want. So they come back on the 28th, and the defendant just simply asks the trial court if it's going to inquire with the jury. The court says yes, and the defendant's attorney says, we have nothing other than that, Your Honor. That's 6656. So there is an inquiry. The juror says, in fact, this time that she's better. She is mentally able to participate. And this time she also says that her previous hesitancy has passed. Yes, she's able to proceed. So now she has 3 times said she's able to proceed. Once on the previous day, when the attorney wasn't sure that she could evaluate it, and now twice. And this time she's actually confirmed that that her previous hesitancy has passed. Defense attorney says the only additional questions he would ask for would be if she had discussed this case with her medical provider or her family. And the defense attorney also notes that she's in a much different place than she was last time. That's on page 6658. When the trial court says, well, I intend to inquire along those lines with all the jurors, his attorney responds, okay. And the court finishes rather than single her out because somebody else could have had a problem along with her. And his attorney says, okay, and I may have follow-up on that. 6658 is our page number. So the court does an inquiry with the entire jury and then asks if the defendant has anything he wants to put on the record. And his answer again is no. That's 6659. The only question that he ever wanted asked was whether she had spoken with anyone else, family or medical providers. And the judge did do that. In fact, the judge asked everybody that because it had been a long break. And it was at that time that the defendant then filed in court the motion to remove the juror. And he did say that he didn't know who sent that message, that if we wait for some inquiry later, the standard will be different. That's on 6662. That there may be more additional information we could get, but we still won't know if it's truthful, if she's really able to participate. And if we don't ask for more inquiry now, we may have waived something. That's on 6663. And that's really our position. There ought to be more inquiry, but we just really feel she should be removed. There were no more questions that he asked, no more questions that he wanted to be asked at all.
Can I just ask you a question? As I heard Ms. Zimmer, she's making an argument there's structural error here, there's constitutional error here, that even though there were at all times 12 jurors, warm bodies in the jury room, that this juror really wasn't mentally, emotionally capable of deliberating for the first, I guess, day and a half or day until that note came out, and that she was in a coercive situation that had nothing to do with even anybody intending to coerce her. It's just the way the situation worked out. That would affect our standard of review, right? That approach would affect our standard of review. And that would be an issue that defense counsel couldn't waive, right? Would you agree with that?
If there had been structural error.
Structural error is not something that defense counsel can waive, right?
Correct, that's correct.
Okay, so would you speak to that? Would you speak to that argument? Because if that's the situation, it doesn't matter for our analysis whether or not Mr. Tyndall waived anything.
Certainly. So the case that the defendant has cited for this structural error is Wilson. In Wilson, our Supreme Court made very clear that that case only applied in situations where a judge had a communication with part of a jury, where the judge gave jury instructions to only part of a jury. And our Supreme Court recently reaffirmed that holding and said that it did not apply to other situations such as these in State v. May. That case is cited in the state's brief. So that actually does not apply here. And what we have is an abuse of discretion standard. And in fact, the standard for reviewing both questions about juror misconduct and whether to grant a request for a mistrial is all an abuse of discretion standard. So even if the defendant or the state or your honors or this court would disagree with the way that the trial court handled this, you can't find that it's an abuse of discretion as long as it's a reasoned decision. And it's a very reasoned decision. When you look at not only the timeline as to how this happened and the position the defendant took, the defendant was in a position where he was uncomfortable with a mistrial as well. And he agreed, and he really didn't even want her to have to make a decision about how she felt until she came back. The defendant's position was that those additional jury instructions were not required. But the trial court here made a decision that in considering the defendant's written motion to remove, the oral presentation and the presentation by the juror herself in open court. And this is important too, because the determination about credibility of witnesses and specifically the credibility of jurors during inquiry about misconduct is always in the discretion of the trial court because credibility is an issue for the court. And in this particular case, considering her answers, the fact that there was no communication whatsoever between any attorney and this juror, and no information was given to her, that what happened with this juror was not something that created substantial and irreparable harm. And mistrials are not supposed to be declared unless, in fact, that is what has occurred. This is not an absolutely a situation that is so surprising. Criminal juries who sit on death cases have a difficult time. This is a difficult thing, and this is not the first time this has come up because it is so difficult. And the trial court recognized that. The defense attorney and all the parties at this point recognized that. And that's why this same thing happened in Julian, where a juror sent out a note that says she was requesting excusal, and that this happened, I believe, on the very next day after they began deliberating in Julian as well. That she was not able to handle someone's fate in her hands. She was emotionally distraught and physically upset since the day before when they began deliberating. That was the statement that she gave. But there was no error in that case. And in that case, there was no inquiry at all. And the trial court actually incorrectly misinformed the jury that it didn't have the ability to excuse a juror. In this case, the trial court was so very careful, it gave the defendant multiple opportunities, and the defendant did not request any questions that the trial court did not already ask. So there just is not an abuse of discretion here. As to issue one, the defendant cannot meet his burden here. His father's statements are not trustworthy. I'm sorry. The defendant's statements are not trustworthy. And there are lots of reasons why these statements were properly excluded, but the bottom line is the trustworthiness problem. According to defendant, his own father is the person who taught him how to lie. According to the defendant's attorneys, his father is a manipulator and is unreliable. According to defendant's own mental health expert, his father had been found to be untruthful previously. And according to the defendant's father, he had plenty, the word he used was plus, reasons to lie to the officers during his statements. And if these statements aren't trustworthy, they can't come in for any reason, because the purpose of the hearsay rule is to exclude these unsworn pretrial statements. And this is even a heightened situation when there is a motive to exculpate a family member. The things that we should consider, and first is that it's well settled that the trial court has broad discretion to determine the reliability of declarations. And the trustworthiness determination is a threshold test made in the trial court's discretion. The peculiar factual context within which the statement is made is what determines trustworthiness. And the focus should bear on the context of the declarant at the time, his motive, whether he's available for meaningful cross-examination, spontaneity, and the relationship. And there are some factors that have already been found to actually indicate untrustworthiness. And that includes a family relationship and a situation where the defendant is actually present and flees the scene with the declarant. In this case, the father's statements were absolutely riddled with reasons to find them untrustworthy. The father actually stated, I'm sorry, since I started with the issue 3. Defendant's father asked about being recorded at least 7 times. And he actually said on page 124 of the defendant's exhibit that he was going to use the recording as a dictation service. On page 133, when he goes for the second trip, he brought a dictation program with him. He referenced his own death multiple times, and he actually said on page 53, if I die, keep in mind, my son should not go to jail. He didn't do anything. He said his primary purpose was to help his son, and he alluded to that multiple times and was very specific sometimes too. On pages 159 through 160, he said, I'm going to be very cooperative because I don't want my boy taking this ride. He called the defendant his buddy, and he said on page 241, what I'm doing here is just for my son. The declarant talked about manipulation, and he asked the officers how to manipulate the media to get an attorney for his son. And he asked the officers to manipulate the prosecutor to get a deal for his son. And he caught himself and backed up and said, not manipulate, influence. He made mental health excuses for his own acts. And yes, he did make mental health excuses for the acts, the crimes that he committed elsewhere in Texas as well. But specifically with this case, on pages 82 and 83, he said he took the bodies in the truck because he didn't want the bones to be found in the fire and people would wonder why the truck was gone. That's just common sense. But he caught himself again and immediately says, I was distraught. I was mentally out there. Otherwise, why would a person do something like that? He also further denies his own culpability, saying that murder is not his forte and he has no experience with neck snaps or blows to the head, both of which, of course, occurred in this case. And he also said he's not a child abuser. His children are the most important things in his life, period, and he wasn't making drugs. But not only are these statements on their own untrustworthy, they actually are contrary to the defendant's own very detailed statements. His father gave very little detail about what happened in this particular case to these victims. He did know there weren't going to be fingerprints found because they were wearing gloves. And he did say that he just wanted money from them, but he did not say much more than that. But his son told a lot more about his participation, and he detailed his participation, the defendant himself did, to the police, to psychiatrists, and to the jury. The defendant in this case told his own mental health expert that camping was a pretext, and he knew that. He told his expert and he told the jury that one of the reasons he went on this trip was because he believed his father wanted to find Holly and kill her, find her and the kids and kill Holly, and that his father was at risk if he was alone without him and he could help prevent that. That's on page 6128 of the transcript. He also said that he packed the car for the trip then when his father made this list of items that the state found. And he admitted that that list that he packed for his father when he's going with him to look for Holly included weapons and duct tape, that he packed the truck and immediately picked up his father. And he admitted to the jury that his father told him beforehand he was going to rob someone and do anything necessary to get as much money as possible. He also said he knew, because they had discussed it, that his father wanted Jerome's truck. They had talked about it. They had talked about robbing him, and his father was going to attack him with chemical spray. Now, he did say, we agreed we would wait and talk about it again in the morning, but he already knew these things. And he admitted to being a lookout and a driver, carrying a 5-foot break-apart spear, rifling through the victim's office during their murders and for hours afterward, carrying the bodies because he said his father could not do it alone, waiting in the driveway for his father as his father set the house on fire, and being the one who led the way. Because at that point, the plan was he would lead the way, and yes, he agreed to that. He also testified that he could reason with his father, and his father listened to him. That was one of the identified reasons he testified about for going on this trip. And he testified that he told the police what happened, and he told the jury these things he did. If there were going to be some sort of statement, pretrial statement, that could be admitted to corroborate the defendant's testimony, that would have been the defendant's own statement, not his father's statement that was contrary to it. But the defendant did not offer his own prior statements. He made a motion to exclude those. These statements are untrustworthy for every reason, and there is no reason. This case is not at all similar to any due process violation situation. And in fact, the United States Supreme Court said that those cases are different when it is a situation where the declarant is actually there and could have been called to testify. This certainly could not have happened in this case. There is, yes, Your Honor.
This question. So, you've just been arguing about this being an untrustworthy statement, a violation of hearsay, should be excluded under the hearsay rules. Yet Judge Height excluded it under Rule 403. Why do you think that is, and how do you defend that analysis?
Well, the decision that the trial court made pursuant to Rule 403 for two things. First, that's an abuse of discretion standard. So the defendant can't prevail on that because there was a threshold question about trustworthiness that was in the court's discretion. But under any sort of standard, those statements are untrustworthy. But the actual determination to exclude these statements when the defendant did make a request to enter the entire set of 10 hours worth of video was a decision that he made in his discretion. It was well articulated. He gave the reasons for his decision, and that is in his discretion. It's true, too, that the defendant never objected under 403, even when the trial court at one point, because there were
what do you mean that? Well, the trial court was applying Rule 403 to exclude the defendant's offered evidence, right? Did the state make an objection under 403?
The state did talk about probative value and said that there would not be an opportunity for cross. What the trial
that's just what I'm okay. Okay.
And the trial court actually made a very careful determination. It outlined, in fact, that although it seemed that some of the declarant statements on their face were against his interest, that in fact they were not against his interest, and that in fact they just could not ultimately be trustworthy because he made the references to his own impending death, which I believe counsel pointed out one of the first things today was that the declarant here killed himself to avoid going to trial. He already knew he was going to do that. Everybody else knew he was going to do that in his family. They all testified that that's why they bonded him out of jail in Texas. Because if he
did the trial court make a determination of whether or not this was a statement against interest, or did the trial court purely make the decision based on what Judge Emmons said, Rule 403?
Well,
whether it's hearsay or not, I just think it's a 403 issue, and I think it's not very probative because it's untrustworthy or whatever. and the prejudice outweighs it. Is that, I mean, did the court make a determination?
What the trial court said was, on their face, these do seem, some of the statements do seem as if they would be, in fact, against the defendant's interest, against the declarant's, interest. But in fact, they're just untrustworthy. And so under Rule 403, and he specifically said pursuant to Rule 403, these statements are excluded.
And the state made an argument that a 403 type argument. I guess that's what you said. Did the defendant counter that or make any argument? No, the defendant said that 403 shouldn't apply.
I don't remember, and I'm not sure that the state made a specific 403 argument, because the defendant never said that himself. They argued over relevance and admissibility, and the trial court. The trial court actually addressed some of this issue prior to the point where he makes his ultimate ruling on all of the statements. The defendant offered part of them to come in through one of the mental health experts that the defendant produced. And the trial court at that time said, I'm going to exclude these under 403 and your objection is noted. But the defendant said, well, we do object pursuant to constitutional, I don't remember if it was 6th and 14th Amendments, but did not object under 403.
Well, can I just interrupt? This was excluded by the trial court who raised 403. I think what Judge Dillon is asking and what I'm asking, looking back at it, in the rearview mirror, I can see the 403 analysis of 10 hours of evidence that you're going to put this jury through, listening to, weighing the probative value versus the inconvenience to the jury. But there would be no reason for the defendant here, Ms. Postel, to raise 403. The defendant was trying to get it in. How rare is that for this evidence to be excluded under Rule 403 for the benefit of the state? Because we hear it all the time where there are 403 motions by the defendant. How often does the state make those motions? Or is this sort of used as belt and suspenders? Basically, well, it's a closed case on the hearsay, so I'll just say 403.
Well, there's established case law where defendants have actually specifically tried to introduce another co-defendant statement. And so drawing from that case law, this is not an absolutely unique situation. So certainly defendants do want, and it's not unusual for one defendant, particularly family members. That's where this case law about the family members comes in.
Right.
For a family member to say, look, I did this all. And there's nothing that my wife did or nothing that my brother did. There are cases with both of those factual scenarios.
And do those cases involve Rule 403 analysis? I didn't see that.
I do not remember if they were 403. Yes. In those cases.
So is the issue before us whether or not the trial court abuses discretion in determining whether this evidence should not have been admitted under 403? Isn't that the sole issue?
Yes.
Is that the issue for us? Okay.
That is the issue, because his ruling was that the prejudicial effect greatly outweighs its probative value for the reasons sought to be introduced in this case, and therefore, pursuant to Rule 403, the objection is sustained. That's his ruling. And that's on page, I believe that's on page 6215. I'm not sure about that page number. So the trial court did say that it was a reasoned decision because it took into account the declarant's personal knowledge, his motivation to speak, the nature and character of his statement, the relationship with his son, and that although on their face, some of the statements on their face were against penal interest, because his primary motivation in making the statements was to benefit the defendant, and looking at the statements themselves and how they were made, circumstantial guarantees of trustworthiness were not present.
Okay, let's say that we determined that the judge erred in not admitting it by using 403. Does the issue then before us, what's our analysis? Is it prejudicial analysis, or is it a harmless beyond a reasonable doubt because now the defendant has not had the ability to present his defense? I mean, if we get there, if we say it was error, what do we look at then? Is it just basically you've got a very high burden as a state to prove, well, it was harmless beyond a reasonable doubt, or we just look at, well, was it prejudicial or not?
Well, it could have been plain error argument, but the defendant didn't raise that. So he's actually waived all review of it. If
They raised the constitutional argument. You said that they said that we do not have the right to, we're not being allowed the opportunity to present a defense now. We object on that basis.
Yes, you're correct. They did do that. And in this case, it would be then if he properly preserved it as a constitutional argument, and I would have to look to see which amendments he referenced. But if he did do that, then the standard would be harmless beyond a reasonable doubt. That would be the state's burden.
So we first have to determine whether or not the trial court abuses discretion, and if we think so, then we would say, did the state prove that any abuse of discretion was harmless beyond a reasonable doubt? Am I thinking about that right?
Well, I think the first thing is whether defendant waived this issue, but then certainly after whether he waived it, the issue is whether the trial court uses discretion. Yes.
So if I'm a defendant and I object based on hearsay, I've also got to say, oh, by the way, this doesn't violate 403, or I waive it. If the judge just jumps in and says, nope, I'm going to overrule your objection because of 4 or sustain it because of 403. I don't see why the defendant would have to make any argument based on that to preserve it, I guess.
Well, our appellate courts in North Carolina have been I see I'm about out of time. If I could just finish.
Now you can answer questions, and you have a minute to wrap up because I'm interrupting you. Go ahead.
No. So our appellate courts in the state have been very clear that when a defendant tries to raise an issue on appeal that is not the same issue that was raised previously, that the defendant cannot. I'm sorry. Now I forgot what your question was.
You can't swap horses. I got you. Go ahead and wrap up. You can go ahead and wrap up.
But wait, but you're not. How are you? I think what Judge Dillon was saying, though, Ms. Postel.
Oh, sorry. Yes.
When the trial court has imposed another analysis to support the state, okay? Let's assume, for the sake of argument, the state raised 403, and the trial court then just made an opinion about it, as opposed to the trial court doing the state a solid and coming up with that theory, okay? Either way, it wouldn't be anything for the defense to waive. The state has argued it.
Well, the defendant can only raise an issue on appeal if you argued it below. And when a defendant argues that the evidence was only admissible, but does not argue about was relevant and admissible, but has not argued specifically that it was more probative than prejudicial, then he's waived that, because defendants are required to make very specific objections and cannot raise on appeal something that he did not give the trial court an opportunity to hear his argument on. So the defendant didn't do that. He did not argue that. And so, yes, a defendant does have to say, not only is this relevant and admissible, but you also is more probative than prejudicial. The defendant does have to go that far and say that. And in fact, this case, this court in Howard found the opposite, where the defendant had made arguments about 403, but did not, and actually used the words 404B, but because his statement was not really about 404B, he had only preserved the 403 argument. So yes, the defendant does have to also say that the statements are admissible and should be admitted beyond the fact that they're relevant, because they are more probative than prejudicial. And because there is no error in this case, certainly not any error that is an abuse of discretion, the state requests that you affirm the trial court's judgments. Thank you.
Thank you so much. Now we're from the appellant. You have 5 minutes.
May it please the court. I'm going to start again with issue 3 related to the juror. With regard to structural errors, the state's argument that State versus May somehow reigns in State versus Wilson to make it inapplicable here, it's not just in cases like State versus Wilson where there was an individual juror who was instructed separate from the other jurors where structural error can occur. The United States Supreme Court recognized in Shepard v. Maxwell, cited in the brief, that there are some processes that are inherently unfair. And that's what this is here. Wilson is not so limited. This is an issue of whether or not there were 12 jurors capable of deliberating. And when that number value we've seen from many cases, Poindexter, other cases in which if there are less than 12 jurors that are competent jurors throughout the trial, there is a structural error. So in this case, we would still contend that Juror Whitney was not a competent juror, and there were not 12 jurors deliberating in this case. I also want to briefly touch on State versus Julian, which was cited in the defendant's brief. There was one incident with the juror. There was one time the juror said she was distraught and incapable of proceeding. Here, we have multiple instances with Juror Whitney. First, we have her report that she's unable to evaluate the case. Then we have a car accident. Then we have her taking every step possible to say, I'm not comfortable, I have reservations, and the judge asking her leading questions to get her where he wants her to go. And I would contend there's no point at which the defense says, we are satisfied with this juror. We are satisfied that she can go forward. During this 30 pages or so of transcript, the defense counsel repeatedly restates reservations, and it yields to the court's rulings as it's required to do under the rules of practice. It's respectful to the court. Defense counsel understands that they are not going to be allowed to directly address the juror, and that would have most likely been improper. Comparing this case and whether to remove this juror, if you look at cases where jurors are removed, it's for much less than what happened here. And I would disagree with the state's analysis and characterization of this exchange that defense counsel was okay with this. Defense counsel repeatedly says, I'm uncomfortable with her. I don't think we know if she's capable of evaluating the case. It's in the excerpts, and I won't read from them. I trust that this court will read and draw its own conclusions. But there is no point at which defense counsel says, we are satisfied going forward with this juror in those words. Turning briefly to the Ed statement issue regarding 403, there are multiple discussions of this statement throughout the trial. To say that the court didn't rule or defense needed to object to the court's ruling on 403 seems to elevate form over function. Everybody knew why the defendant wanted these statements to be admitted because they
Okay, tell me why it was an abuse of discretion. Let's assume it's preserved. So why was it an abuse of discretion for the trial court to make this ruling based on 403?
I do think these statements were incredibly probative. Again, this is a case without any eyewitness testimony besides Eric. There's not a lot of physical evidence here regarding who did what. We have minimal DNA evidence. There's no fingerprint evidence. So what happened in that house and how this all played out was significant to what Eric's role was and his level of guilt. And here, the only other person who could have said what happened was Ed. And he did tell officers what happened in the house regarding getting the guns from the Faulkners, the crossbow going off when Mrs. Faulkner grabbed at it after they wouldn't give him money. Ed's statements to Eric during the procedure and what Eric told police that Ed told him about taking the truck. His statements to the officers that Eric didn't pick the house. These are consistent with Eric's testimony and very probative, I would contend. So, and I see that I am out of time. So I just thank you again and request that this court grant Eric a new trial.
Thank you so much. Thank you for your excellent arguments. We'll take Mr. Campbell's appeal, the issues raised under advisement. And Mr. Sorrell, will you adjourn court?
This session of the North Carolina Court of Appeals is now adjourned.
Thank you.
Thank you, ladies.
Thank you.
Now I guess we'll take a break and join the other one.
Yeah, I'll be with you in 2 minutes.
Okay.
Thanks. What an